Aaron.
Yeah.
Why didn't you say it the first time I said Aaron?
Because it's pronounced Aaron?
You done messed up, Aaron!
Aaron is here. Welcome back, everybody, for more SPTV, where every day is a great day not to be in a cult. All right, we're going to do something a little bit different here. I've actually never done a video quite like the one that I'm about to do, and I'm kind of excited about it for no really great reason. I just like the fact that we're changing things up here a little bit. So Danny Masterson just filed what are going to be his final words before his appeal gets ruled on. And this is his appeal in his criminal case. He's serving 2 consecutive life sentences in prison right now. Technically speaking, it's 30 years to life, but it's a lot of years. And but Danny's most recent filing is really part 3 of a trilogy of filings that I haven't really done any videos about. Because some of these filings, the first one started with Scientology's amicus brief that it filed on behalf, like if Scientology literally put in its own brief for why Danny Masterson's rape conviction should be overturned. That was a stunning filing that I don't even think I did a video about. Part 2 of the trilogy is the California Attorney General's response to Scientology's amicus brief. A stunning filing. Again, I don't think I did a video about it. And then now we have Danny Masterson's own final word in response to the amicus brief and the state's response to Scientology's amicus brief. So what I'm going to do, I'm going to read the entire filings. This is going to be a long video. I'm not going to rush through it. I'm going to read it as if this was the audiobook version of the filings. I have myself not even read these filings all the way through. And I'm looking forward to this, and I hope you're looking forward to it. And when I'm done with this live stream, I'll chop it up and I'll publish the separate segments to the Clips channel. But you know, if a lot of you are like me, you prefer listening to things than reading them. I do all my books, audiobooks. I love listening to things while I'm doing other things rather than sitting down and reading them. Well, I guess I'm now going to force myself to sit down and read these things because there's nowhere I can go to just listen to them. So I will do the reading and you guys can do the listening, and we'll finally use these microphones the way they're intended to be used, which is instead of shouting throughout my videos as I normally do, I'm going to calmly read in a quiet speaking voice, and let's see how this goes. Buckle up. These are long filings. All right, let's see here. So this is Scientology's amicus brief that it filed in the Danny Masterson appeal. The people, plaintiff, and respondent versus Daniel Peter Masterson, defendant and appellant. Amicus brief of the Church of Scientology International in support of defendant and appellant. So that's Danny Masterson and Danny Masterson. Introduction and interests of amicus. By the way, guys, Scientology tried to file this last December. The court rejected it. They tightened it up a little bit and refiled it again just last month, actually. And the court finally accepted it. Okay, Danny Masterson's conviction was irretrievably tainted by First Amendment violations in a way that improperly decided religious questions and smeared his religion. These violations denied him a fair trial and, in the process, subjected all Scientologists and other people and institutions of faith to intolerable added risks merely for embracing and practicing their most sacred beliefs. Imagine, for example, a Catholic being tried on criminal charges in a trial where the judge states that Catholic beliefs are relevant to whether a crime was committed, egregiously misinterprets canon law, and uses that mischaracterization to justify the otherwise inconsistent testimony of complaining witnesses at a preliminary hearing, bases the decision to bind the Catholic over for criminal trial on that false reading of doctrine, continues to use the false statement of canon law throughout the trial, despite being told by church authority that this interpretation is wrong, allows a defrocked former nun to testify as an expert on Catholic doctrine, and permits the prosecution to malign the church and its teachings at will, thus making the case as much about Catholicism as the alleged crimes. Imagine, too, that the judge shows overt hostility to the church throughout judicial comments and actions, then instructs the jury to consider heretical testimony about church teachings for the truth of the matter, in deciding guilt or innocence. This should be unthinkable in an American court committed to constitutional neutrality. Yet that is precisely what occurred, albeit with a different religion in this case. And it was an affront to the Constitution and contrary to deeply rooted judicial precedent, especially considering Scientology's status as a relatively new and unfamiliar religion. To help the court understand how the First Amendment was transgressed here, this brief will first describe some Scientology-related events of the trial, including repeated mischaracterizations or fabrications of Scientology doctrine and practice. The brief will then detail how the First Amendment was repeatedly violated by state actors in two distinct ways. First, the trial court improperly decided religious questions and allowed religious issues to be put to the jury in determining whether Masterson was guilty. In doing so, the trial court, in clear violation of the First Amendment, allowed Scientology and mischaracterizations about its beliefs and practices to become a central part of the case. So extensively that the words Scientology and Scientologist were repeated 800 times, more often than variations of the word rape, the charged crime. The state in its response brief continues this disturbing pattern with 60 more references to the Scientology religion than to the alleged crimes. The trial court's rulings thus allowed a stream of testimony that contradicted and ridiculed the church's beliefs and practices, and which the court presented for the truth of the matter for evaluation by the jury. The second way the First Amendment was violated involved governmental hostility towards Masterson's religion, manifested in ways that infected nearly every aspect of the case. This hostility extended beyond the religious animus of the police detectives and prosecuting attorneys who investigated, charged, and prosecuted this case with the direct participation of a Scientology apostate who had engaged in a years-long public campaign of vitriolic attacks on the faith. I believe they're referring to Leah Remini there. The trial court itself exhibited a lack of neutrality and even hostility to the Scientology faith through its treatment of courtroom visitors suspected of being affiliated with the church, its comparison of the church to violent gangs and white supremacists, and by its prejudicial rulings. And the state, in this very appeal, has continued the pattern of governmental hostility by including in its brief gratuitous, irrelevant testimony hostile to the church. The First Amendment does not allow government actors to show non-neutrality, much less the hostility shown here to any faith. The interests of Amicus Church of Scientology International in this case are by now clear. The church condemns rape and all forms of sexual violence, but no Scientologist will be safe if courts may judge members of the faith by substituting the court's own invention of Scientology doctrine for the religion's actual teachings, let alone issue rulings and allow hostile comments based on those erroneous inventions. And no faith community of any kind will be safe if judges are allowed to interpret scripture to resolve evidentiary issues or to present religious issues and evidence to a jury to use in deciding whether a defendant is guilty of criminal charges. Additional background. A. Overview of the Church of Scientology and relevant Scientology scripture. Church of Scientology International is the mother church of the Scientology religion, recognized by the IRS as a tax-exempt church. CSI oversees the application of Scientology religious doctrine in Scientology churches, missions, and groups in more than 167 countries, including the United States. CSI is responsible for defending the Scientology religion and preventing the misuse of its doctrine. As a religion established in the mid-20th century, as compared to Judaism, Christianity, Islam, and Buddhism, which have existed for millennia, Scientology's doctrine and practices may be unfamiliar to many. Scientologists are not modern Benedictine monks cloistered in enclaves separate from society and adhering to their own invented mores and laws. Rather, they are as much woven into our nation's fabric as are Baptists, Roman Catholics, or members of the Jewish faith. Scientologists can be found in all walks of life. They are accountants, actors, doctors, musicians, school teachers, football players, mechanics, and bus drivers. And they are to be found throughout our country's cities, suburbs, and rural towns, where they vote, celebrate the 4th of July, obey the law, go to church, contribute meaningfully to their communities, and take their kids to the park like everybody else. Good Lord. Against that real-world backdrop, Scientology scripture leaves no ambiguity regarding the duties and conduct expected of its members with respect to criminal behavior. The church's written doctrine commands obedience to the laws of the land, condemns criminal behavior, and recognizes the rights of victims. But despite this clear doctrine, in the proceeding below, state actors repeatedly asserted the opposite, purporting to define Scientology doctrine themselves. The court began this cascade of constitutional violations at the preliminary hearing, where it improperly interpreted the teachings of defendant's faith against him. Okay. The gravity of the court's error was compounded by the fact that its interpretation was flatly wrong. This mischaracterization of Scientology doctrine launched an onslaught of false statements about the religion that were advanced and repeated multiple times by the court, the prosecutor and or the prosecution's designated expert throughout the trial. They repeatedly attributed to Scientology doctrine that does not exist, presenting these fabrications as if they reflected actual church scripture. Each instance imposed the state's forbidden interpretation of church scripture in place of the religion's own ecclesiastical authority, creating a false and distorted picture of the religion to prejudice the jury. This was done despite the church's attempts to avoid such misinterpretation through filing an amicus brief. Okay, I will comment on this right here. Throughout the preliminary hearing and even throughout the trial, the judge herself continued to say that if the defense or Scientology's representatives, who were there sort of as a part of Danny's team, kind of as like consulting members of Danny's criminal defense team, if there were issues about whether Scientology or claims that Scientology was being misrepresented by the ex-Scientologists or by the attorneys, Danny's team was perfectly capable of providing their own actual Scientology expert, instead of just saying, you're a liar and you're not allowed to say that and you can't tell Scientology what Scientology believes. The judge said, David Miscavige himself is welcome to come up here and take the stand and give his interpretation of what Scientology actually believes. So I just wanted to say that. All righty, next paragraph. These misinterpretations were not incidental. They served a tactical purpose to bolster the credibility of the complaining witnesses and to create a hostile environment for Masterson's faith in the courtroom to his prejudice. By falsely claiming that Scientology doctrine forbade contact with law enforcement or required internal handling through Scientology law, the prosecution transformed its mischaracterizations of religious belief into an evidentiary explanation for the complaining witnesses' conduct. In doing so, the state improperly allowed its case to rest not on evidence, but on perversion of faith. Because courts may not determine or define religious doctrine, amicus now sets forth the authoritative doctrine of the church on the matters the state and the court purported to interpret. As the ecclesiastical authority authorized to provide a declaration of Scientology doctrine, amicus declares below the official church doctrine to which courts are required to defer on the core doctrinal issues that were raised during these proceedings, and which amicus was expressly denied any opportunity to rebut there. Okay, fascinating. They were definitely not denied an opportunity to testify in a court of law. Okay, B, mischaracterization of Scientology doctrine on reporting crimes by other Scientologists. The trial court, the prosecutors, and their purported expert, which was Claire Headley, by the way, falsely claimed throughout the trial that Scientologists are forbidden from reporting crimes committed by other Scientologists to law enforcement. This assertion, presented as a fact to the jury, has no basis in Scientology doctrine. Oh my God. It's literally a core element of Scientology doctrine. The false depictions of defendants' faith that permeated the trial originated in the preliminary hearing, where the court held Masterson over for trial based on its own misinterpretation of Scientology doctrine. And I guess this is a quote from a previous proceeding. The court's findings of credibility at the preliminary hearing stage is based both on its evaluation of the witnesses as they testified and the exhibits received, including People's Exhibit 5, the Scientology Ethics Book, and People's Exhibit 6, the written Scientology policies. These exhibits indicate that the written doctrine of Scientology not only discourages but prohibits one Scientologist from reporting another Scientologist in good standing to outside law enforcement. This expressly written doctrine sufficiently explains to this court the hesitancy and lateness in reporting the crimes charged to law enforcement, and also explains the inconsistencies in the witness's testimony and the actions taken subsequent to the events that comprise the charges. Thus, based on the testimony and exhibits presented, the court finds there is sufficient evidence to bind Mr. Masterson over for jury trial. All right. The court's statement of church doctrine was flat out wrong, yet the court used its interpretation to explain away the complaining witnesses' inconsistent stories and their prolonged delay in reporting. After the ruling, the church provided the court with its authoritative explanation of Scientology doctrine, making unmistakably clear that the court's interpretation had no basis in scripture. Rather than correct the error, the court rejected the church's clarification and adhered to its own invented construction of doctrine. I get it. So after the preliminary hearing, the judge rejected Scientology's attempt to get the court to modify its ruling. All right, carrying on. This flawed ruling fatally infected all subsequent proceedings and became the law of the case. Subsequently, for example, in ruling on a motion in limine, the court allowed testimony at trial that Scientologists are prohibited or discouraged from reporting other Scientologists in good standing to outside law enforcement or face repercussions for doing so. The court then instructed the jury prior to deliberation that it could consider evidence of Scientology to explain the alleged victim's belief regarding Scientology principles and practices related to A, reporting another Scientologist in good standing to outside law enforcement. It is patently absurd for a court or anyone to undertake to interpret a religion's doctrine by reading just a few passages of scripture. That is especially so here, given that the written and recorded spoken words of L. Ron Hubbard comprising the scripture of Scientology include tens of millions of words, including 25 books, some 100 encyclopedic volumes, scores of films, and more than 2,500 recorded lectures. Moreover, the court's statement that the expressly written doctrine of the church prohibits one Scientologist from reporting another Scientologist in good standing to outside law enforcement is dead wrong. The court did not cite to any expressly written doctrine for this proposition, and it could not. The so-called expressly written doctrine does not appear anywhere in the doctrine of the church. The court reached this conclusion only by substituting its own language for the text before it, attributing to Scientology a rule that appears nowhere in its scripture. In fact, the church has no doctrine prohibiting or discouraging members from reporting the criminal conduct of Scientologists or of anyone to law enforcement. Indeed, church doctrine explicitly demands Scientologists abide by all laws of the land, including criminal law, as stated in the very text relied upon by the court for its ruling. Unbelievable. Okay, fine. I guess I am reading the whole thing. Let me take a sip. Hold on. It's funny. I'll just opine on this briefly. There are actual opinions published by judges that it has been demonstrated to the court that Scientologists in good standing will lie in any way that they need to in order to protect Scientology. And obviously that would extend to Scientology itself. So Scientology is basically saying nobody but the Church of Scientology itself can claim to know what Scientology scripture actually says. And if you think you can just read a paragraph or even one policy letter, or God forbid, even one book, and claim to know what Scientology actually believes, that is impossible, because Hubbard wrote tens of millions of words. And based on Scientology's position, no ex-Scientologist, no former Scientologist could ever be used as an expert or an authority on what Scientology believes, because they are hopelessly biased. And only a current Scientologist, or actually the Church of Scientology itself, is a reliable source on what Scientology believes, with the only problem that a Scientologist will lie, and the only one who has no incentive to lie is a former Scientologist. It's an amazing circular logic that Scientology tries to play on the court here, and it's not going to work. Okay, as stated in the very text relied upon by the court for its ruling, preliminary hearing People's Exhibit 6. Quote, nothing in this policy letter shall ever or under any circumstances justify any violation of the laws of the land or intentional legal wrongs. Any such offense shall subject the offender to penalties prescribed by law, as well as to ethics and justice actions. Okay, fine. That's from the Scientology ethics book. The court's misreading of the doctrine was particularly egregious, given the court ignored the closing commandment in the very same policy, which was read aloud by defense counsel prior to the ruling. Quote, additionally, Your Honor, if you actually look at both the book under the Suppressive Acts, Suppression of Scientology and Scientologists, and in People's 6, which is really just a photocopy of that same chapter in the book, Your Honor, at the second to last page of People's 6, it states, I'll put it on the screen here, nothing in this policy letter shall ever, or under any circumstances, justify any violation of the laws of the land or intentional legal wrongs. Any such offense shall subject the offender to penalties prescribed by law, as well as to ethics and justice action. All right, a quick more opining on this. It is just kind of a classic nature of the Scientology books, the way they're edited, the way they're compiled, the way they're published, that they just have contradictions in them that serve Scientology's purpose, right? Like you list the list of high crimes and the high crimes and the crimes and the misdemeanors. And amongst that list, it literally says reporting another Scientologist to the civil authorities is a crime. But then there's just and so if you are a Scientologist and you're being basically tried on your offenses, that line will be pointed to as the thing that you violated. But yet, when you're in a court of law, there's a little caveat. Oh, nothing in this chapter or this book or this policy letter should ever be construed to condone any violation or any, legal wrongdoing. And you're like, but that is exactly how it is construed in Scientology. And that's what matters. So anyway, I'm glad the judge didn't fall for this in the case. All right, let's keep going. This language is universal across Scientology justice doctrine and directly forecloses any claim that Scientologists are prohibited or discouraged from reporting crimes. And it likewise expressly mandates that any offender shall be subject to the penalties prescribed by law. Consistent with that mandate, church doctrine further states, crimes may result in suspension of certificates, classifications, or awards, reduction of post, or even dismissal or arrest when the crime clearly warrants it. All right. In fact, while Scientologists are overwhelmingly law-abiding, the church and its parishioners do report to law enforcement Scientologists engaged in criminal conduct. No approval is required from the church to report criminal activity by a Scientologist or anyone else, or even to take him to jail. This is so false. At the preliminary hearing, the prosecution argued that the following Scientology text, which sets forth conduct considered to be a suppressive act, a high crime in Scientology, supported its interpretation of church doctrine as barring reports to law enforcement. Quote, delivering up the person of a Scientologist without justifiable defense or lawful protest to the demands of civil or criminal law. Scientology's founder, L. Ron Hubbard, wrote this doctrine on the same day as the doctrine discussed above, providing that crimes may subject a Scientologist to arrest, and it plainly does not provide that a Scientologist may not report another Scientologist for committing crimes. The trial court did not merely misinterpret the passage, it replaced the text with an entirely different rule of its own making. My God, talking about beating a dead horse here. Indeed, the trial court disregarded the actual language of the text, which reads, delivering up the person of a Scientologist. The trial court instead cited the scripture as if it were a prohibition on reporting another Scientologist in good standing. Those are different words carrying entirely different meanings. By substituting its own wording for the text before it, the court attributed to Scientology a doctrine that does not exist in any authorized scripture. L. Ron Hubbard did not write reporting another Scientologist in good standing, or even delivering up a Scientologist. He wrote delivering up the person of a Scientologist. The phrase the person of is a long-standing English expression and has a specific definition. It means in the character of, as representing. Oh my God, that's not even what I thought they were going to say. 1, person, a character sustained or assumed in a drama or the like, or in actual life, part played, hence function, office, capacity, guise, semblance, one of the characters in a play or story, now chiefly of the dramatis personae or characters in a drama. In the person of equals in the character of, as representing, Oxford English Dictionary, 1961. Good Lord, this is horrible. Quote, all right, delivering up the person of a Scientologist thus refers to someone who is delivered up simply because he is a Scientologist for the offense of being a Scientologist or practicing Scientology. I had not read this yet. I'm reading this for the first time. What Scientology is claiming that phrase actually means. They are insisting it means something that no Scientologist has ever understood it to mean, ever. And it's not what it means at all. Like this is catching me by like they're surprising me here. There's no Scientologist who has ever interpreted that it's not a phrase, it's not even a sentence. Delivering up the person of a Scientologist. I thought they were going to say it meant, no, that means his actual body, the person. I have it on my person. It means your actual body. Anyway, this is wild, you guys. We'll keep going. Okay. Oh my God, they're giving up another definition. They're doing dictionary definitions here. Okay. 2, deliver, to give up entirely, give over, surrender, yield, formally, often, specifically to give up to an evil fate, devote to destruction, ruin, or the like. Also with over, obsolete, or archaic. My God. The correct meaning of the doctrine is easily understood by inserting the word Jew, Muslim, Catholic, or Christian in place of Scientologist. The act of delivering up the person of a Jew. What? Okay, the act of delivering up the person of a Jew in, I don't know how to say this city. Is that Vichy? Is it Vicky? Is it Vichy? Nobody will ever know. Okay, Vichy. All right. The act of delivering up the person of a Jew in Vichy, France during World War II means something quite different than merely reporting a crime committed by a person of the Jewish faith to lawful authorities. Accordingly, the doctrine provides that delivering up a person to civil or criminal authorities for the mere fact of being a member of the Scientology faith and or practicing Scientology is a suppressive act, a high crime in Scientology. That is precisely and only what the doctrine means. This is literally an insane interpretation, okay? First of all, L. Ron Hubbard did not write the list of crimes and high crimes in Scientology in an environment where it was illegal to be a Scientologist, okay? I'm just going to go back. I know my main goal here is just to read the amicus brief, but delivering up the person of a Scientologist without justifiable defense or lawful protest to the demands of civil or criminal law. There is literally no interpretation of that sentence that would a reasonable interpretation that would be giving up a Scientologist to the authorities for the crime of being a Scientologist. Like, this is absolutely wild. I can't believe they tried to totally rewrite what that thing is supposed to mean. Okay. The historical context of that teaching is also instructive. The doctrine was written in 1965 in response to oppressive and outrageous persecution of Scientologists in Australia, where the Parliament of Victoria had issued a ban on Scientology and enacted legislation making it a crime to be a Scientologist. Bans by the states of South Australia and Western Australia followed. That is true that was happening in Australia. It is a total fiction that L. Ron Hubbard publishing the list of crimes and high crimes in Scientology was related to that. Total fiction. 3, the Parliament of Victoria enacted the Psychological Practices Act 1965, Act number 7355, making it a crime punishable by up to 2 years imprisonment to teach Scientology, advertise it, or hold oneself out as willing to teach it. The act further made it a crime to possess any Scientological records and authorized the Attorney General to search such person or premises for such Scientological records and to conduct such searches at any time of the day or night with such assistance as may be necessary, and if necessary, to use force by breaking open doors. While Scientology was vindicated long ago in Australia, there still remain repressive nations that do not recognize or respect freedom of religion. 4, the act and other bans were repealed in 82 and 83. In 83, the High Court recognized the wrongness of the act, finding without question that Scientology is religious. This decision stands to this day as the most significant Australian authority on the question of what constitutes a religion and the guiding decision used for determining a religious charity in Australia. For example, 5 Scientologists in St. Petersburg, Russia, were imprisoned and put on trial in 2020 for charges related to practicing Scientology. On October 1st, 2021, the Russian Ministry of Justice listed 2 Scientology-related entities as undesirable, thus making participation in those organizations a crime. 5, the undesirable designation means that the cited group represents a threat to the security of the Russian Federation, and that any Russian citizen who supports the Scientology-related organizations may be subject to criminal prosecution. The European Court of Human Rights awarded damages to a Scientologist who was detained by the Russian government solely for being a Scientologist. Quote, delivering up the person of a Scientologist without justifiable defense or lawful protest to the demands of civil or criminal law is thus considered a suppressive act or high crime in Scientology. When members of the religion are persecuted and prosecuted for their religion, Scientologists have a moral obligation to rightfully stand up and defend the person of a Scientologist. The doctrine emphatically does not forbid one Scientologist from reporting another Scientologist to law enforcement for criminal behavior. History has recorded the atrocities that can be committed against members of a religion whose doctrines are misrepresented and its followers delivered up without justifiable defense or lawful protest. It was similarly wrong for the trial court in this case to allow the jury to be influenced by a false narrative suggesting that it was Scientology doctrine that prohibited witnesses in this case from timely reporting the criminal violations alleged here. All right, well, I just feel the need to sort of mention again, and I guess ask you guys for your opinion on this. It's very easy for Scientology to cry after the fact that the court allowed ex-Scientologists and non-Scientologists to assert the truth of what the Church of Scientology actually believes. But why didn't Danny Masterson's criminal defense team put their own Scientology expert on the stand to testify about what Scientology does actually believe? My opinion is that it's easy to just write things in these documents and claim them to be true. But once you're on the stand, you don't just get to testify. You have to be cross-examined. And there is no Scientology expert who's a current Scientologist that could stand up to a cross-examination of the Scientology belief system and what they actually believe. And particularly in Danny's case, the role that Scientology policy played in blaming the victims, shaming the victims, silencing the victims, protecting Danny Masterson, and preventing his victims from reporting him to the police. That is why the criminal defense team didn't put their own Scientology expert on the stand. Okay. C, compounded mischaracterizations of Scientology doctrine. The court's original misinterpretation that Scientologists are forbidden from reporting their fellow parishioners was followed by a cascade of further distortions of Scientology scripture that permeated the trial. By adopting an invented doctrine on the reporting of other Scientologists, the trial court opened the door to further inventions, including through testimony by an apostate presented as an expert on Scientology. And the court enabled the prosecution to weave a false narrative in which virtually every inconsistency in the complaining witness's conduct was explained away by reference to the court-created doctrine and the subsequent falsehoods it spawned. The prosecution's closing argument demonstrated the extent to which the court-created doctrine and its progeny permeated the trial. And this is, I guess, from the closing arguments here. Quote, now, like all predators, the defendant carefully sought out his prey. His victims are particularly vulnerable. Most of his victims are members of the Church of Scientology, and that makes sense. The church taught his victims, rape isn't rape. You caused this. And above all, you are never allowed to go to law enforcement. What better hunting ground? In Scientology, the defendant is a celebrity, and he's untouchable. Now, in order to understand these victims, in order to understand these crimes and what happened, it's extremely important to understand their association, their belief in the Church of Scientology. It affected the way they thought. It affected their actions. It affected their decision to wait and not report these crimes. In Scientology, they weren't important. The person that was important was the defendant. He was the upstat. And that's why you heard from Claire Headley, the state's expert. She informed you about what Scientology believes, that Scientology law, their rules, their principles, they guide everything. They're the controlling factor. You must obey those rules over all other laws. The victims, well, they can't be victims. And whatever they did, they caused it to themselves. The defendant, a celebrity in good standing, any complaint filed against him would be filed with a yawn, meaning Scientology would discredit it and would investigate the people who made their allegations, investigate the victims. These false statements of church doctrine embedded in the prosecution's closing argument and made throughout the trial fall into several doctrinal themes. Each reflects a distortion of Scientology scripture. One, Scientology doctrine requires obedience to law and the reporting of criminal conduct. For example, the prosecution told the jury that Scientologists must obey Scientology's rules over all other laws, and its purported expert claimed that when secular law and Scientology doctrine conflict, a Scientologist will follow the law of Scientology. These statements bear no resemblance to the Scientology doctrine. It is church doctrine to obey the laws of the land. Right, but it doesn't say obey the laws of the land over other Scientology policy that might conflict with laws of the land. All right. Scientology doctrine mandates that every Scientologist obey all civil and criminal laws, and any violation of those laws subjects the offender to civil and criminal penalties as well as to ecclesiastical discipline. As already shown, church scripture explicitly provides, quote, nothing in this policy letter shall ever or under any circumstances justify any violation of the laws of the land or intentional legal wrongs. Any such offense shall subject the offender to penalties prescribed by law, as well as to ethics and justice actions. This doctrine applies universally. Far from elevating religious rules above secular law, Scientology doctrine expressly identifies criminal conduct as a suppressive act, the most serious violation of church ethics codes. This is laughable. In fact, any felony such as murder, arson, etc., against person or property is listed as the first suppressive act before any ecclesiastical offenses. The obligation to obey secular law includes the duty to report criminal wrongdoing to law enforcement. The prosecution and its purported expert told the jury that a Scientologist must report wrongdoing only to a church ethics officer, not to secular authorities. This claim is also false. Scientology recognizes civil law and religious ethics as distinct but complementary obligations. Reporting a crime to law enforcement fulfills one's legal and civic duty. Reporting ethical lapses within the church serves a separate religious purpose aimed at spiritual improvement. Scientology scripture is explicit on this point. L. Ron Hubbard taught, and Scientology doctrine teaches, what's wrong? Can you guys see me? Can you hear me? You can hear me. Okay, I'm going to put myself back on. I'm going to go out. I'm going to come back in. Okay, so you guys can hear me, but you can't see me. This is really weird. I'm going to leave the studio and come right back in, okay? Don't you go anywhere now. Leave studio. Leave studio. All right. I think you guys can see me again, or at least, yeah, you can see me again. That was super, super weird. All right, let's carry on, shall we? Scientology scripture is explicit on this point. L. Ron Hubbard taught, and I'll just, for the hell of it, double check my audio since I'm paranoid about that. Yep, we're still good. Okay. L. Ron Hubbard taught, and Scientology doctrine teaches, that an individual cannot make spiritual advancement while burdened by criminal conduct for which he has not taken responsibility, meaning conduct he has not confessed, confronted, or made good. Church scripture recounts instances in which L. Ron Hubbard himself directed parishioners who had committed criminal acts to report themselves to the police and to make good on the harm caused, including instructing a Scientologist to settle these matters with the police, which he is doing quite commendably. This principle that one must take full responsibility for one's conduct lies at the heart of Scientology's ethics. Nor does Scientology doctrine punish those who report wrongdoing to the church, as the prosecution falsely argued. Punish those who report wrongdoing to the church. Oh, like punish victims. I got it. The obligation to report unethical, destructive, or criminal conduct is long established in church policy. For example, one such policy issued in 1965 states staff members must personally make certain reports in writing. 11, a misdemeanor report, any misdemeanor noted. 12, a crime report, any crime noted or suspected, but if suspicion only, it must be so stated. 13, a high crime report, any high crime noted or suspected, but if only suspected, it must be so stated. A second policy issued that same year demonstrates that the prosecution's claim that individuals are punished for reporting wrongdoing is the opposite of church doctrine. No person may be penalized for issuing an ethics chit. This is absolutely wild. First of all, there is absolutely a policy in Scientology called ethics protection. And it does talk about what happens if someone is submitting an ethics report against a high producer who's considered an upstat and has ethics protection. And it absolutely says the report will be filed with a yawn and an investigation began on the person who wrote the report. It 100% says that. And also, there's a little bit of a straw man argument of saying, whoa, no one is ever punished for reporting a crime. Well, no, your punishment isn't for reporting a crime. Your punishment is for writing a report on an upstat. It's a little different. And honestly, Scientology can just say whatever the hell they want, because really their position is only we can say what we believe. Only we can say what we believe. You can't read our words and tell us what we believe. You cannot make us bleed our own blood. Okay. They continue. This principle was later reaffirmed in one of the church's best known doctrinal writings, Knowledge Reports, which makes the duty to report explicit and penalizes interference with reporting. Quote, forbidding anyone to write a knowledge report makes the person forbidding it and the person accepting this illegal order both accessories to any later action taken. Scientology neither forbids nor discourages reporting wrongdoing to law enforcement. It requires obedience to civil law, imposes a duty to report unethical and criminal conduct, and protects parishioners who report misconduct. That's very interesting. I challenge any Scientologist to write a report on David Miscavige and find out if in Scientology you can ever be penalized for reporting wrongdoing. Now, Scientology would say, well, you're not being penalized for reporting wrongdoing. You're being penalized for making up lies about dear leader Miscavige. And that's exactly what they would say about one of their celebrities. It's not writing the report that you're getting in trouble for. It's trying to damage their reputation with lies. Alrighty. Next, number 2, Scientology doctrine recognizes victims and assigns responsibility to wrongdoers. The prosecution told the jury that Scientology doctrine teaches that victims are to blame for the abuse they suffer. Scientologists are told, you caused this, that whatever they did, they caused it to themselves, and that they can't be victims. At times, this was framed in terms of a supposed Scientology doctrine that a person pulled it in. There is no such doctrine. The phrase pulled it in does not appear in Scientology scripture. Oh my God. And no church policy or practice places responsibility for criminal acts on the person who was harmed. In fact, recognition of victims is embedded in Scientology from the very beginning. Scientology's foundational text, Dianetics, the modern science of mental health, is devoted to the harmful physical, mental, and spiritual effects of painful experiences, injuries, and abuses inflicted on an individual. That is, to the ways a person can be harmed or victimized. Far from denying the existence of victims, Dianetics begins from the fact that individuals suffer lasting trauma from what has been done to them. The entire subject of Scientology is rooted in addressing the harmful effects of what has been done to an individual. All right, so instead of Dianetics, the modern science of mental health, I guess they're saying it should read Dianetics, you are a victim. Okay. Nothing in Scientology doctrine suggests that a person is responsible for being harmed by another. Scientology's entire ethics and justice system is premised on providing justice and recourse for individuals who have been wronged. The Scientology dictionary, moreover, defines victim in the same plain sense understood by courts of law: one who is harmed by or made to suffer from an act, circumstance, or condition. I'm sorry. I have to jump in. Then why is the word victim in the Scientology dictionary? That's interesting. If victim is just a normal word and it has no special connotation or weight in Scientology, then why is the English word victim in the Scientology dictionary? There's a reason, because there's an entire special derogatory significance in Scientology to the word victim. And by the way, the Scientology dictionary doesn't just give definitions explained out the way a normal dictionary would. It actually just gives quotes from L. Ron Hubbard in various places where he's talking about victims. Okay, let's see here. No church doctrine prohibits recognizing victims or forbids use of the word. 7, victim. I guess we're playing the dictionary game here. 7, victim. One who is harmed by or made to suffer from an act, circumstance, or condition. One who suffers from a destructive or injurious action. Scientology dictionary. It's hard to read this much. All right. This recognition of victims is also expressed in Scientology's ecclesiastical structure. Really? Every Scientology church and mission includes a chaplain whose role is expressly defined in church scripture. That's so funny. Almost no Scientology org in the world actually has a chaplain. Okay, I guess this is a quote from an L. Ron Hubbard policy letter about the post of chaplain. To succor those who have been wronged and to comfort those whose burdens have been too great. Scientology's ministry reflects this same recognition in the work of the volunteer minister, a role L. Ron Hubbard created as a worldwide ministry. In establishing this ministry, L. Ron Hubbard stated, "The quality of being religious implies 2 things. First, a belief that evil, pain, bewilderment, and injustice are fundamental facts of existence. Second, a set of practices and related sanctified beliefs that express a conviction that man can ultimately be saved from those facts." I can't believe they're getting into the volunteer minister program to try to disprove the idea that in Scientology, you were taught that you're responsible for anything that has ever happened to you. And they're like, but have you heard of the volunteer ministers? I mean, have you heard that we hand out bottles of water at earthquake zones? I mean, what are you talking about? Danny Masterson, what? He couldn't have raped anybody. There was a typhoon there and there were volunteer ministers there, you guys. Okay. L. Ron Hubbard further described the volunteer minister's role. A volunteer minister does not shut his eyes to the pain, evil, and injustice of existence. Rather, he is trained to handle these things and help others achieve relief from them and new personal strength as well. Ugh. This is tedious. Okay, these doctrinal statements make unmistakably clear that the Scientology ministry's purpose is to confront suffering, injustice, and harm wherever they appear, and to provide practical spiritual assistance to those who have been wronged or overwhelmed. Far from denying the existence of victims, Scientology's ministry is expressly directed towards recognizing, assisting, and uplifting them. One of the most extraordinary claims the prosecution and its expert advanced about victims was that rape isn't rape and that Scientologists are forbidden from using the term. No, it's not that Scientologists aren't allowed to use the term. It's that you weren't allowed to put it in reports that were being sent up to management. They know what they're doing here. Okay, that claim collapses instantly when measured against Scientology's actual doctrine. The term rape appears 497 times across 184 separate doctrinal writings. Oh my God. Oh my God. All right, I'm skipping paragraph 8. I can't. Okay. From the earliest materials, including his seminal work on human behavior, Science of Survival, L. Ron Hubbard identifies rape as destructive and antisocial conduct, placing it among the lowest levels of human conduct. For example, he further describes a rapist as an individual who uses sex as a punishment and displays a range of extreme antisocial traits, including disregard for ethics, insincerity, immorality, active dishonesty, fascistic tendencies, and a heavy liability to society. These descriptions make unmistakably clear that rape is regarded in Scientology as among the most destructive and reprehensible acts a person can commit. The notion that Scientology doctrine would minimize, excuse, or protect such conduct is irreconcilable with these foundational teachings. Under no reading of Scientology doctrine could a rapist be afforded leniency, protection, or doctrinal shelter of any kind. In short, responsibility in Scientology lies with the wrongdoer, not the victim. The prosecution's claim that Scientology teaches victims, including victims of rape, that they pulled in their abuse or that they can't be victims is false. 3, Scientology ethics applies equally to all Scientologists. In another serious mischaracterization, the prosecution told the jury that in Scientology, the defendant is a celebrity and he's untouchable. And in response to any complaint made against him, the church would investigate the victims. The prosecution's purported expert offered similar assertions, suggesting that Scientology doctrine affords preferential treatment to favored parishioners or those deemed important. These statements are false. No Scientology scripture, policy, or practice provides special treatment, protection, or exemption for any parishioner, celebrity, or otherwise. Guys, this is absolutely mind-blowing. There is a policy letter in Scientology about the status called Kakan. And L. Ron Hubbard tells some historical tale of some, warrior in whatever civilization it was. I guess, was it who are the Mongols? Is it the Mongols that Genghis Khan was in the head of or whatever? And he tells this tale that a particularly brave act committed by a warrior would be rewarded with the status of Kakan. And what this means is that once awarded this Kakan status, you could be forgiven the death penalty 10 times over. Such was your protection. This in Scientology, you can literally be labeled a Kakan. It hardly ever happens anymore because David Miscavige doesn't respect people that way. But L. Ron Hubbard did it, and John Travolta was awarded the status of Kakan. John Travolta was the first big celebrity. John Travolta was publicly promoting Scientology long before Tom Cruise was willing to talk about it. Now, I've seen this discussed publicly as if you're awarded the Kakan status in Scientology, it means you can commit murder. You can be forgiven for murder. That's, it means you can get away with murder, and that means figuratively. So if there's a status in Scientology where you can get away with, be forgiven the death penalty 10 times over, right? And usually what are you given the death penalty for? Usually taking another life, right? It is figurative, but it also it's illustrative. It speaks to the fact that in Scientology, there is such a thing as people who are more valuable are protected. And that is simply a fact. That applies to staff members who are simply have high statistics or are good at making money. And it applies to celebrities. Celebrities are considered upstats in Scientology. Celebrities are considered valuable and are protected. So anyhow, this is a work of fiction. Okie dokie. To the contrary, Scientology ethics and justice codes apply equally to all members without privilege, exemption, or special treatment. These codes are contained in doctrinal policy letters in which L. Ron Hubbard makes the point explicit. Quote, policy letters apply broadly to all organizations and Scientologists without exception. Yeah, of course they do, including the policy letters talking about ethics protection and upstats and Kakan status. No one's denying that the policy letters themselves don't apply equally. But then, I see what they're doing. They're being cute. They're like, well, but if this policy letter says this is a crime, then that means this is a crime for everybody. Yes, it is a crime for everybody, but not everyone is held accountable for having committed the crime to the same level because upstats have ethics protection. Anyway, they're being cute. Okay. Likewise, the Code of a Scientologist, to which every Scientologist must pledge, states, as a Scientologist, I pledge myself to the Code of Scientology for the good of all, to embrace the policy of equal justice for all. Oh, that's cute. Church doctrine does not make exceptions. It does not distinguish between parishioners based on status, notoriety, or position. Consistent with this doctrine, members, including well-known members, have been expelled for serious ethical violations because the justice codes apply without exception. Scientology ethics and justice derive from written policy, not from personal status or discretionary favor. Scientology doctrine provides no special category of parishioner who is exempt from accountability or whose misconduct is ignored. Scientology doctrine does not include a policy of fair game. At trial, the prosecution's purported expert witness falsely claimed that Scientology doctrines claimed that Scientology doctrine includes many policies that cover fair game, which she described as permitting Scientologists to discredit an enemy of Scientology. That assertion is false. There is no doctrine of fair game within the Scientology religion, and there is no Scientology policy titled fair game. Fair game is a term intentionally misinterpreted by anti-Scientologists to unfairly tarnish the church. In its original and limited use, the term simply indicated that an apostate was no longer entitled to seek the protections of the church's internal ethics and justice system. Owing to continual misinterpretations by anti-Scientologists, the use of the term was canceled in 1968, and the words were removed from the two policies in which they appeared. In the authorized published works for the church, comprising some 75 million spoken and written words, the phrase fair game has not appeared for over 57 years. It is therefore impossible for the prosecution's witness or so-called expert witness to have encountered this phrase in any authorized Scientology scripture. The prosecution's characterization of church doctrine is false. It is a matter of church orthodoxy that the policy the prosecution purports to characterize has been canceled. Throughout the development of Scientology doctrine, hundreds of policies have been canceled in this manner, and those canceled policies similarly do not appear anywhere in church publications. Whenever any policy is canceled, Scientology orthodoxy maintains it is no longer church doctrine, period. These repeated false statements about the faith would have been troubling enough, but over and over, whether from the prosecution, its expert, or the court, Scientologists were portrayed as separate from and fundamentally opposed to American society. Through references to Scientology law, their rules, their principles, and similar characterizations. This was a calculated and extensive effort at othering, the act of treating someone as though they are not part of a group and are different in some way. Such othering of religious minorities has marked some of the darkest chapters in history. Such treatment of any group in our nation, regardless of their race, gender, national origin, sexual orientation, religion, or any other characteristic, should never occur. It is particularly odious in our justice system. Summary of argument. Finally, as noted above, the judge, prosecution, and their purported expert repeatedly mischaracterized Scientology doctrine and doctrine-based practices, a violation that began at the preliminary hearing and continued throughout the trial. Individually and collectively, these mischaracterizations were a key factor in Masterson's conviction and in the First Amendment violations that permeated the trial. Ecclesiastical abstention. First, the trial court sought to make its own determinations of Scientology doctrine. This alone violates the Constitution, but to make matters constitutionally worse, the court did so in contravention of the church's own authoritative declaration. It is long settled First Amendment law that whenever the questions of discipline or of faith or ecclesiastical rule, custom, or law have been decided by the highest of the church judiciaries to which the matter has been carried, the legal tribunals must accept such decisions as final and binding on them. Yet here, the trial court erroneously determined the meaning of Scientology scripture, choosing an apostate's harmful and incorrect reading on multiple points, and refused to accept the church's authoritative statements. The U.S. Court of Appeals for the Seventh Circuit made clear that this is constitutional error, when reversing a lower court that had submitted a religious dispute to a jury and ignored the church's authoritative determination on the issue. Besides being prejudicial to Masterson, the decision here was deeply dangerous to members of the church more generally, as well as to members of all faiths. Additionally, the trial court allowed false and misleading evidence of alleged Scientology practices and beliefs to be submitted for the truth of the matter, purportedly to aid the jury in its decision. But this too is forbidden by the First Amendment. Religious animus. Government actors also violated the First Amendment in displaying hostility to the Scientology faith. The First Amendment requires strict neutrality towards religion, such that even the slightest deviation from neutrality violates the Constitution. Yet here, by repeatedly showing a lack of neutrality toward defendants' faith, the trial court and other government actors repeatedly violated the First Amendment. Argument. The opening brief summarizes the two main First Amendment violations in this case. Here, amicus provides additional relevant context and authority, including explaining in more detail why these errors prevented Masterson from having a fair trial and wreaked havoc on the entire framework of religious liberty protected by the First Amendment. One, the trial court violated the First Amendment by deciding religious disputes and by presenting other religious issues to the jury. The trial court's failure to heed the First Amendment's prohibition on determining religious matters or allowing them to be presented for determination by the jury was particularly clear in the court's decisions to interpret Scientology scripture and to admit evidence regarding Scientology doctrines and practices for the truth of the matter. These violations not only harmed Masterson, but a decision affirming those rulings would also endanger the rights of all Scientologists and indeed all faith communities and their members. The trial court improperly and erroneously interpreted Scientology scripture. The court's decision to interpret Scientology scripture arose from the fact that there were no eyewitnesses to the alleged rapes, and hence the credibility of the complaining witnesses was the seminal issue at the preliminary hearing and at trial. The accuser's credibility was particularly important given their years-long delayed reporting to police and inconsistent statements about those alleged crimes to third parties, law enforcement, and in court. Hence, the prosecution and the complaining witnesses decided to blame their delay on the church. This blame is unsupported by the evidence. For example, Jane Doe 2 left the church in 2005. She did not report to the police until 2017, 12 years later, a delay that could not possibly be attributed to her purported Scientology beliefs. Okay, judicial interpretation of Scientology scripture violated the First Amendment. For example, at trial, the prosecutor argued that the reporting of a Scientologist in good standing to law enforcement is a religious high crime. This false statement of Scientology doctrine resulted from the trial judge's misinterpretation of Scientology scripture at the preliminary hearing. The trial judge, moreover, did not just slightly misinterpret the scripture. She gave it a reading proposed by an apostate of the faith, which was the opposite of what it means. The trial court then went beyond scriptural interpretation, which itself was a violation of the First Amendment. The court doubled down by taking sides in a religious dispute between the church and the state's apostate expert, which was also an independent constitutional violation. As the U.S. Supreme Court put it over 40 years ago, under the First Amendment, it is not within the judicial function and judicial competence to determine whether one side or the other in litigation has the proper interpretation of the faith. Okay. Compounding these constitutional violations, the court proceeded to use its false version of Scientology doctrine as a foundation for its finding that the charging witnesses were credible. Masterson was obviously and severely prejudiced by that ruling. The court committed a similar First Amendment violation when it declared in its post-trial findings and order that Masterson remains a Scientologist in good standing to the present day. Really? This was problematic from both an evidentiary and a constitutional perspective. As to the first, no evidence had been submitted as to Masterson's current standing in the church. Oh my God, they're implying he might not be in good standing. That's playing with fire. Rather, the prosecution in the closing argument had stated as fact that Masterson was a member in good standing, and the trial court took it and declared it as religious truth. More importantly, whether someone is a member in good standing of a religious organization is a theological determination, one constitutionally inappropriate for courts to make. And that is especially so when no evidence, such as a declaration from the church, had been submitted. As another example, earlier in the proceedings, the trial court, sua sponte, instructed the prosecutor to do an internet search for the date of Tom Cruise's wedding as a means to determine whether Leah Remini was a Scientologist in good standing at a specific point in time. Such an instruction would be extraordinary on its own, but all the more problematic given the First Amendment violation, the court determining whether someone was or was not a member of the faith in good standing. The court used this intrusion into the realm of religion in support of its order, squashing a defense attorney request. So isn't that interesting? I don't remember at what point in the preliminary hearing this issue came up regarding Leah Remini. But it does make sense that only a Scientologist in good standing and not an ex-Scientologist would be welcome at Tom Cruise's wedding. And so it sort of makes sense that the judge would be like, okay, so if we're going to, apparently something came up that made it relevant whether Leah Remini was or was not a Scientologist in good standing at a particular year. And I guess the thing was, okay, well, let's just see when she went to Tom Cruise's wedding, because we at least know she was in good standing up until that point. But guys, that was unconstitutional. Okay, 2, the trial court's refusal to defer to the church's authoritative interpretation also violated the First Amendment. The court's refusal to defer to the church's reading of its own doctrine was a clear constitutional violation, as the U.S. Supreme Court put it just over a decade ago. All right, I'm not reading the whole thing. By interpreting religious doctrine and taking an apostate's side in a religious dispute, the trial court did just that, thus plainly and doubly violating the First Amendment. Okay, good. We get it. Judicial abstention from scriptural interpretation and from taking sides in religious disputes is required not only by the Constitution, but by the most basic common sense regarding the limits of secular courts. All right, fine. B, the trial court improperly allowed evidence of the meaning of Scientology doctrine and practices through a biased expert and in a manner that invited the jury to resolve religious disputes. The trial court's First Amendment violations did not end there. The court also allowed the trial itself to become a forum for deciding what was true about Scientology, from allowing a biased expert on Scientology to permitting the prosecutors to make false statements about Scientology doctrine and internal policy. All this is precisely what the Constitution forbids. Expert witness. While expert witnesses are a normal part of civil and criminal litigation under the First Amendment, they cannot be used in determining the truth of religious matters. That was made clear, for example, when the Supreme Court found it constitutionally inappropriate for a state court to countenance an expert witness on internal church procedures. Similarly, the D.C. Circuit affirmed a district court's refusal to allow expert testimony on religious issues because after a week of trial, the district court found that no expert testimony could effectively filter out the religious elements from the secular ones sufficiently to avoid unwholesome and impermissible entanglement with religious concerns. All right, we're gonna jump forward here a little bit. Religious truth. Here, by contrast, the trial court impermissibly allowed the jury to consider the truth or falsity of Scientology doctrines and religious practices by ruling that a Scientology apostate, Claire Headley, could testify about those matters as an expert witness. As the prosecution made clear in its closing statement, moreover, Headley's testimony was admitted for the truth about Scientology, not what the alleged victims subjectively believed. She informed you, quote, she informed you about what Scientology believes. That Scientology law, their rules, their principles, they guide everything. The trial court's expansive ruling on Scientology evidence authorized, among other things, expert testimony regarding Scientology, including how Scientology doctrine related to whether Masterson committed the crimes of which he was accused. Okay. All right, real quick, I am just going to give myself a little bit of an expectation of how much more is left. I knew it was long. Oh no, you guys. All right, we're skipping ahead. We are absolutely skipping ahead because we got 2 more fucking things to read. All right, let's look at this one. We're going to go down to closing argument. The prosecution's non-neutrality and hostility towards the Scientology religion was most clearly on display in closing arguments, where the prosecution made multiple false and pejorative statements about the Church of Scientology and its beliefs, and essentially urged the jury to convict the defendant because he was a member of the church. The prosecutor told the jury Masterson was to be convicted because his faith was a billion-dollar organization that's retaliating against the complaining witnesses. Masterson was to be convicted so the jury could show these victims that there is justice, since they did not receive justice from the church. They were retaliated against by their church, which told them there is no justice for them. The prosecution falsely declared that Masterson was to be convicted because, according to expert Claire Headley, Scientology operates under its own law. You must obey those rules over all other laws. And Masterson was to be convicted because he was a celebrity in good standing and protected by the church, which would discredit any internal complaints. Furthermore, the prosecution falsely claimed that the church punished the alleged victims. Having set up their closing through an extended broadside attack on the church, the prosecutor's final message to the jury was that it should punish the church for its supposed mistreatment of the alleged victims by punishing Masterson. And not surprisingly, the jury responded to the send the church a message ploy by convicting Masterson. In all these ways, the prosecuting attorneys, government officers, and officers of the court violated the strict neutrality toward religion that Masterpiece says the free exercise clause demands. Instead, the prosecutors repeatedly showed hostility to Masterson's faith and church, putting the church on trial alongside Masterson and presenting it in as bad a light as possible. These statements are unquestionably as non-neutral or hostile as those in Lacumi, Masterpiece, Merriweather, and Fellowship of Christian Athletes. Such animus the Constitution cannot abide. All right. Conclusion. This appeal does not merely present a question of trial error, but a question of constitutional boundaries that state actors crossed again and again. This case illustrates why strict adherence to the First Amendment is mandated in a criminal prosecution, not only to protect the defendant, but to protect every faith community whose beliefs or practices may be misunderstood or maligned, including, in this case, all Scientologists. Here, by both improperly deciding religious questions and repeatedly displaying hostility toward Masterson's faith, the trial court and the prosecution impermissibly crossed clear constitutional lines. If these constitutional violations are allowed to stand, no member of any faith will be safe. Courts are forbidden from interpreting scripture and using religion to determine guilt or innocence. The First Amendment does not permit such a result in this case or any other. Boom. I have good news, guys. The state's response is not as long as that. How long is it exactly? It's actually not that bad. It's actually not that bad at all. Thank God. And then we can get to the meat of what the title of this video is really about, is what are Danny Masterson's last words on this issue? Okay, let me cue this up here. All right. The person making this next response, it says Rob Bonta, Attorney General of California. Charles Ragland, Chief Assistant Attorney General. Susan Sullivan Pithy, Senior Assistant Attorney General. Scott A. Tarl, T-A-R-Y-L-E, Tarl, Supervising Deputy Attorney General. And the woman who actually did it, the one who made the presentation, at least the one who did the oral arguments, is Blythe Lezkay, Deputy Attorney General. You spell her last name Leszkay. Lezkay? We'll never know. All right, let's read it, guys. That's what we're doing. I said it was going to be a long, boring video. It's long and boring. but I'm glad that we're doing this. Respondents' answer to brief of amicus curiae. By the way, my understanding is that the state did not actually have to file a response to Scientology's amicus brief, but the state informed the court they wanted to file a response. They wanted their shot at this. Okay, introduction. The parties' briefing addressed whether the First Amendment was violated below. Appellant's sixth claim on appeal alleged error from the trial court's admission of Scientology evidence for the truth of the matter asserted, as well as the trial court's purported hostility to Scientology. Respondent disagreed, explaining that the challenged evidence was relevant and admissible, and that the court remained appropriately neutral towards Scientology. Amicus, the Church of Scientology International, addresses this issue, asserting that the First Amendment was violated in multiple ways. First, CSI provides an overview of Scientology and its relevant doctrine, which it says unambiguously commands obedience to the laws of the land, condemns criminal behavior, and recognizes the rights of victims. CSI sets forth the authoritative doctrine of the church to which it believes the trial court and this court are required to defer. CSI further argues that the trial court improperly decided religious disputes, presented religious disputes to the jury, and permitted a biased apostate to testify as an expert, knowing her testimony differed from the official doctrine. Finally, CSI argues that the court and prosecution demonstrated hostility towards Scientology. Most of CSI's arguments appear directed toward vindicating its own rights rather than those of the appellant, Danny Masterson. But this is not the appropriate proceeding or forum to decide such matters. It is unclear, for example, how the official doctrine could have been properly used at trial, let alone by the court in this appeal. Moreover, CSI's core complaint that the policies discussed at trial were fabrications and contrary to official doctrine is more properly directed at the evidence rather than the court's rulings. But CSI's proclamations cannot alter the evidence. To assist the court, additional relevant pretrial proceedings are summarized to supplement the relevant background from the respondent's brief. Additionally, the arguments below show that neither the court nor jury decided religious issues, that the Scientology evidence was relevant because it was the victim's religion, not because it was the appellant's religion, Danny Masterson, and that there was no religious bias against Scientology as a relatively new and unfamiliar religion. For those reasons, as well as those set out in the respondent's brief, appellant's First Amendment rights were not violated and the judgment should be affirmed. Summary of additional pretrial proceedings. The amicus brief presents statements by the trial court that strips them from their essential context in an effort to support its positions. The respondent's brief has already discussed the context of many of those statements. However, respondent now sets forth the context for several additional statements in the record on which the amicus brief focuses, mostly from pretrial proceedings, which were not already summarized in respondent's original brief. Before the preliminary hearing, appellant filed a brief asserting that the prosecution and law enforcement had exhibited anti-Scientology bias throughout the investigation and required that the magistrate preclude any reference to Scientology. Okay. One, the motion included reference to an OW write-up dated June 2003 and purportedly authored by Jane Doe 1. Appellant used the document to attempt to discredit Jane Doe 1 before she even testified by explaining that it stated her April 2003 encounter with Masterson was consensual. The motion also connected Jane Doe 2's realization that what appellant did to her was rape with her realization that Scientology was a cult. The court noted the inconsistency of the defense position, attacking the victim's credibility based on their lawsuit against the church and general anti-Scientology bias, while also asserting that Scientology has nothing to do with the case. Okay, I'm going to skip the quotes. 2, appellant and CSI try to use the court's method of counting words to suggest that the prosecution was and that respondent is more focused on Scientology than on the actual crime of rape, based on the number of times each is mentioned. However, such a method does not account for euphemisms like incident, act, attack, crime, charge, offense. Regardless, as shown in the quoted passage, appellant's defense centered the victim's Regardless, as shown in the quoted passage, appellant's defense centered the victim's credibility, which made the Scientology evidence more probative because it related directly to that issue. Additionally, while the rapes were always the central issue in the people's case, frequent use of the word rape or its synonyms was unnecessary to convey their accounts of the crimes, particularly since the victims were unconscious most of the time. The court concluded that obviously both sides have their perspective on how it's related. The court permitted limited Scientology evidence. Defense counsel could ask the victims about their civil suit and biases against appellant and the church, and the prosecution could bring out the victim's fear of Scientology and or harassment as it goes to both their then existing state of mind and as to go to their credibility today. During cross-examination of Jane Doe 3, defense counsel asked if she learned that reporting a fellow Scientologist to the police is a suppressive act in any of the leading texts involved in Scientology. Jane Doe 3 explained that the Scientology ethics book states that reporting a Scientologist in good standing to law enforcement is a high crime and a suppressive act. Defense counsel asked Jane Doe 3 if it would refresh her recollection to review the book, and she said it probably would. Guys, this was a remarkable moment in the pretrial. It was Danny Masterson's attorneys who introduced the ethics book as evidence in the trial. It was not the prosecution. Counsel continued asking about Jane Doe 3's relationship with the church, and the court reminded him Scientology is not a defendant in these two incidents. After additional questions about Scientology, the court stopped the counsel and explained that it allowed Scientology issues to come in as it relates to the witness's then existing state of mind to explain the delay in reporting to law enforcement and credibility. After a break in the proceedings, Jane Doe 3 indicated that she had reviewed the Scientology ethics book, including the chapter entitled Suppressive Acts, Suppression of Scientology and Scientologists. At defense counsel's request, Jane Doe 3 indicated that she did not see any reference in the section counsel pointed out that explicitly said that filing a police report is a suppressive act. On redirect examination, Jane Doe 3 testified about the Scientology ethics book, and the magistrate asked if it was going to be marked for identification since both sides are using it. The book was marked for identification, and appellant did not object. Jane Doe 3 testified to her belief that Scientology views law enforcement as the enemy, which it says it in the book as well. She summarized the book as saying, the criminal justice system, law enforcement, FBI are corrupt and we can't trust them. They call it WOG law. WOG is a derogatory term for people who aren't Scientologists. Jane Doe 3 identified specific passages in that book and other Scientology texts as supporting her explanation. She summarized these policies in the context of her hesitancy to report appellant as meaning she cannot trust law enforcement or the criminal justice system. She explained that the section defense counsel had identified referenced civil authorities rather than police officers, but she understood and had been told that it meant police, law enforcement, sheriffs, FBI. On re-cross-examination, defense counsel challenged Jane Doe 3's interpretation of the policies, and the following exchange occurred. Defense counsel, well, nowhere does it say reporting a Scientologist to the police is a suppressive act, correct? The court will interpret the pages that were just shown according to the court will review it at the time that I make my decision. Defense counsel, well, the prosecutor just read you a phrase, delivering the person of a Scientologist without justifiable defense or lawful protest to the demands of civil or criminal law. That means to frivolously report someone. It doesn't mean you can't report someone, correct? Prosecutor, I'm going to object that that's counsel's interpretation. The court, sustained. You can ask what it meant to her. As I said, the court will ultimately decide what relevance or weight that necessarily has on the witness's credibility. Defense counsel. So it was your understanding that reporting any Scientologist to the police was deemed a suppressive act. Is that correct? Yes, yes, sir, said Jane Doe 3. Defense counsel, even if you were justified? Yes, sir. That's not what the phrase says at all. Objection. Defense counsel, correct? Prosecutor, counsel is testifying. Court, it's argumentative. Defense counsel, Scientologists are allowed to report themselves to the police if there is a justifiable reason for doing so. Correct? Jane Doe 3, I believe you have to ask the internal justice chief. Oh, she might have said internal justice chief instead of international justice chief, but it's the same thing. I believe you have to ask the IJC permission. Okay, throughout the preliminary hearing, the magistrate limited the Scientology evidence and reminded the parties that it was being admitted solely to assess the victim's state of mind and credibility. After hearing argument, the court explained the applicable standards, elements, and definitions. When discussing the defense of mistaken belief in consent, the court noted that it could consider only what was admitted in evidence, including the circumstances of the crime and the texts that the defense has brought up. The court determined the victims to be credible, explaining the court's findings of credibility at the preliminary hearing stage is based both on its evaluation of the witnesses as they testified and the exhibits received, including People's 5, the ethics book, and People's 6, the written ethics policies. These exhibits indicate that the written doctrine of Scientology not only discourages but prohibits one Scientologist from reporting another Scientologist in good standing to outside law enforcement. This expressly written doctrine sufficiently explains to this court the hesitancy and lateness in reporting the crimes charged to law enforcement, and also explains the inconsistencies in the witness's testimony and the actions taken subsequent to the events that comprise the charges. After the preliminary hearing, appellant moved to set aside the information under Section 995 on the ground that the First Amendment was violated by the court, basing its credibility finding on an inaccurate and unconstitutional interpretation of religious doctrine. The people opposed the motion. CSI applied to file an amicus curiae brief regarding court order interpreting religious doctrine in violation of First Amendment. Notably, CSI did not object to the defense counsel's use of its scripture in cross-examination and has never suggested such use was problematic. Instead, CSI asserted that the court's order holding appellant to answer for 3 counts of forcible rape violated CSI's First Amendment rights. Wow. Interesting. Through its brief, the Church of Scientology International attempted to correct the record on the doctrine of Scientology. The reviewing court explained its limited role was to review the magistrate's finding of sufficient evidence to bind appellant over for trial. The court explained that the issues CSI raised were beyond the scope of its authority. CSI's counsel stated that rather than making a finding on mental state, it expressly made a finding as to what Scientology doctrine is. The court said that the magistrate made a finding as to the credibility of the witnesses, which is beyond your scope. That's all I'm concerned with. The court accordingly denied CSI permission to file the amicus. The motion to dismiss was also denied. Appellant filed a writ of mandate in this court, which was summarily denied. He petitioned the California Supreme Court to review the following question: where a trier of fact reviews and interprets canonical texts to make independent determinations about religious doctrine and uses those determinations to assess credibility and weigh the evidence against a defendant in a criminal case, does that violate the First Amendment? Appellant's petition for review conceded that the ecclesiastical abstention doctrine developed in and has routinely been applied to intra-church disputes, which are exclusively civil in nature. He described the limited ways the doctrine has been applied in criminal cases and argued it should be extended to include the magistrate's review of Scientology texts as part of its credibility determination. The Supreme Court requested and received an answer from the LA County District Attorney's Office. Appellant filed a reply and the petition was denied on June 1, 2022. Further proceedings addressing the admission of Scientology evidence at trial are summarized in the respondent's brief. In some, the court permitted evidence about Scientology as relevant to explain the victim's conduct before and after the crimes. Before the first trial, the court found that the victims could adequately explain any policies that affected their behavior. After the first trial, where the defense was a broad-based charge of fabrication, the court determined it would be appropriate to additionally permit an expert testimony about the relevant policies. The court explained that such evidence went to the reasonableness of the victim's belief and actions. Argument: the court did not adjudicate a religious dispute or decide the correct interpretation of church doctrine, nor did it ask the jury to do so. CSI argues that the trial court violated First Amendment by improperly and erroneously interpreting Scientology scripture. The amicus specifically complains that the magistrate misinterpreted Scientology doctrine at the preliminary hearing in its determination that a sufficient case existed to proceed to trial. CSI further asserts that the subsequent rape trial was transformed into a trial about the beliefs and practices of the Church of Scientology. Even though CSI provided the court with its authoritative explanation, the trial court did not correct the error. To the contrary, the trial was not about the meaning of Scientology or the correct interpretation of its doctrines. Neither the trial nor this appeal will decide or impact the policies, beliefs, or actions of the church, its officials, or its members. Rather, as discussed in the respondent's brief, the limited evidence about Scientology, the common practices of its members, and the victim's belief about the church was admitted for the purposes of explaining how it impacted the victim's decisions, any reporting delays, and the victim's and witnesses' credibility. The mere fact that Scientology policies and their meaning, as understood by the sworn witnesses, were discussed in the proceeding below did not transform this case into a referendum on Scientology or its doctrine. Okay. Whew. All right. Given this, it is unclear to what end CSI has offered its official church doctrine in this case as an amicus, either in the trial court or in this court. Neither the outcome of the trial below nor of this appeal will have any effect on CSI or its doctrine. CSI was not convicted of any crimes. The jury's guilty verdicts are against appellant only. Indeed, the convictions do not even impact appellant's ability to practice his religion or express his religious beliefs to the extent that he is able to do so in prison. Regardless of what the official church doctrine is, it should not and cannot alter the evidence or outcome of this case. Once a defendant has been found guilty of the crime charged, the fact finder's role as weigher of the evidence is preserved through a legal conclusion that upon judicial review, all of the evidence is to be considered in the light most favorable to the prosecution. Okay. CSI's core complaint that the policies discussed at trial were fabrications and contrary to official doctrine is more properly directed at the weight of the evidence rather than the court's rulings. Even if the victim's fear of reporting the rapes or other church members' conduct in dissuading them from reporting and in harassing them were all based on a misunderstanding of official church doctrine, the subject was still highly relevant to the victim's credibility. Right. That makes sense. Moreover, under the facts of this case, it would have been impossible to excise all testimony about the church or its policies. For two of the victims, the church was the first place that they reported. And the only reason the third victim did not report to them was because of the response she received when reporting a prior rape. In addition to their relevance as to the victim's state of mind and actions at the time, the facts surrounding the reports were admissible under the fresh complaint or prior disclosure doctrine. All right. As discussed in the respondent's brief, admitting the church policies and practices discussed at trial did not violate appellant's religious rights under the First Amendment. Indeed, appellant's religion was barely relevant. The Scientology evidence was admitted not to show that appellant somehow acted in conformity with his religious beliefs, but to show that the victims acted in conformity with theirs. In other words, there was no suggestion that Scientology directed its members to commit rape. It was because the victims were Scientologists that they believed they could not report appellant's crimes to the police, but only to the church. The fact that appellant was also a Scientologist was relevant only insofar as that impacted the victims' responses to the rapes. Jane Doe 3 was shown a policy that prohibited her from reporting appellant because anyone who reported a celebrity or upstat would be investigated themselves. Jane Doe 3 was told that appellant would not have to go to ethics because he was flourishing, which helped her realize she would have to leave him. Jane Doe 1 was told to remove from her knowledge report the fact that she had intended to shoot appellant because the president's office would disapprove if she wrote that she was going to shoot a celebrity. Jane Doe 2 did not report appellant to the church, in part because he, Danny, would be protected as an opinion leader. As a celebrity and opinion leader, appellant was revered in the church and sort of above the law. To demonstrate the irrelevance of appellant's religion to the trial, we can imagine a scenario where he followed a different religion than the victims. If appellant were Catholic, for example, and the church policy to protect celebrities extended to those who were not Scientologists, evidence about Catholicism would be irrelevant and inadmissible. However, because the victims would have experienced the same treatment from their religion, the Scientology evidence would remain relevant and admissible. To the extent that CSI's brief is intended to vindicate its own rights, which many of its arguments suggest, this appeal is not the appropriate forum. 2, the First Amendment does not prohibit an apostate from testifying as an expert. CSI also alleges the trial court's decision to permit Claire Headley to testify as an expert. Neither appellant nor CSI suggest that Headley was unqualified under the law applicable to expert testimony. Instead, CSI argues that by permitting her to testify, the court took an apostate's side in a religious dispute. However, this was not a religious dispute, and the court did not take any side. The court specifically instructed the jury that a witness was allowed to testify as an expert and to give an opinion, but you are not required to accept it as true or correct. The meaning and importance of any opinion are for you to decide. You must decide whether information on which the expert relied on was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. Instead, had the court deferred to the official doctrine and prohibited Headley's testimony because it contradicted that doctrine, as CSI urges, it would have been taking sides in a dispute over religious doctrine. That's interesting. That's obviously true. Throughout its brief, CSI takes issue with the fact that the policies discussed in testimony were wrong, false, fabrications, and contrary to its official doctrine. CSI correctly states that it is improper for a court to determine whether one side or the other in litigation has the proper interpretation of the faith. But that is precisely what CSI is suggesting the trial court should have done. For the trial court to defer to CSI's official doctrine and prohibit evidence as to any other interpretation, even if it was a witness's genuine understanding, the trial court would necessarily be determining the proper interpretation of the faith. Moreover, CSI did not object to appellant's use of its texts in cross-examination during the preliminary hearing, even though defense counsel was the first to introduce them. CSI's arguments demonstrate that its concern is not that the court permitted expert testimony, but that it permitted testimony that differs from CSI's official version. However, the trial court here simply permitted a qualified expert to testify under the rules of evidence. In doing so, it did not take sides in a religious dispute, and that, ironically, is CSI's objection. It is not unusual or problematic that evidence of religious tenets as understood by the relevant parties and to the extent they are relevant to determining guilt are admitted in evidence. It is also unremarkable that there might be differing interpretations of religious doctrine or that people might understand a church's teachings as something different than the official doctrine. For all these reasons and those discussed in the respondent's brief, the First Amendment did not prohibit use of an expert in these circumstances. Scientology was not targeted as a new and unfamiliar religion. In an attempt to expose supposed religious bias against Scientology as a relatively new and unfamiliar religion, CSI invites the court to imagine that the identical case had been brought against the Catholic defendant. But this example instead demonstrates the admissibility of the religious evidence and neutrality of the proceedings in this case. Take the example of a Catholic man who raped a fellow congregant, and imagine if the congregant disclosed the rape to her priest. If the priest instructed her that she could not use the word rape, that she could not claim to be a victim because she had brought the action upon herself, and that she would be excommunicated if she reported the rape to the police. There is no question that she would be permitted to testify to those facts in a subsequent rape trial where there was a delay in reporting. If the priest's instructions were consistent with the victim's understanding of Catholic doctrine, she could testify to that as well. If the priest referred to certain Bible passages and used them to justify his instructions, that could also be properly considered. And the admissibility of those matters would not depend on whether they were correct interpretations of official Catholic doctrine. All of these matters would be highly relevant to the victim's state of mind, her perception of the rape itself, her response to it, and any delay in reporting. If the defendant challenged these points at trial by suggesting that the victim was fabricating about both the rape and her understanding of Catholic teachings, and a qualified expert was available to testify that the instructions were in fact taught in the church, such evidence would be permissible too, as relevant to the reasonableness of the victim's state of mind on those points. Assuming the Bible or other official Catholic doctrine contained contrary teachings, they would be irrelevant to the sole question at trial, whether the defendant raped the victim. Critically, none of this evidence would impact the defendant's religious freedom in any way. It would similarly be irrelevant that the official Catholic Church doctrine forbids child molestation. If a priest who molested altar boys used church teachings to justify his behavior, and if, after learning of the molestation, church officials similarly used teachings to dissuade the victims from reporting to the police and kept the priest in the fold. Good Lord. The same would be true if instead of a religion, these events unfolded in a company. There we go. Imagine a small family-run business where an employee raped another employee who then informed their boss. If the boss had the victim write a report for human resources, but forbid her from using the word rape, positioning herself as a victim, or informing authorities, and also provided her with company policies to support such a report, those facts would be admissible in a later trial. To the extent that there might have existed company policies forbidding rape, they would be irrelevant if they were not abided or discussed by the parties. In short, to the extent that a religious entity's policies or teachings act to silence crime victims and shield criminals, they are relevant and admissible in a prosecution where the criminal defendant attacks the victim's resultant silence to suggest she is lying about the crime and the policies. That is true regardless of the entity. The First Amendment does not shield religions or religious actors where their actions and teachings impacted a victim's state of mind as to the crime committed against her. This case is not a dispute about Scientology's tenets. The jury's verdict did not determine what Scientologists believe. This case is about whether appellant committed rape, and the jury's verdicts determined that he did. There was no First Amendment violation, and for all the reasons discussed herein and in the respondent's brief, the judgment should be affirmed. Oh, good Lord. Thank God that wasn't nearly as long as the original amicus brief. Oh, my God. My throat is literally starting to hurt. Like a muscle cramp in my throat from speaking this long. But we have finally got to the third act, Danny Masterson's response to all this. All right, let's take predictions. We're an hour 45 into this. How many minutes will it take me to read Danny's part? And how much of this am I going to skip over? Okay, let me give this a quick. Oh, you know what? It's not even that bad. It's not even that. Oh, it's not even that bad. Okay. It's not bad. Okay, good. Whew. I didn't really know what I was in for, you guys. I had not previously read any of these all the way through before. Oh my God. Okay. I need more. Oh God. I need to prepare myself. 17 and a half minutes. Northern Girl says 17 and a half minutes, 22 minutes. I see 30 minutes. My goodness gracious. Whoo. Okay. This is what we are all here for. Danny's reply. This is the final act. Okay. And the truth is, though, honestly, the reason why it occurred to me to just read all of these three things through is because to truly understand what Danny is, the context of Danny's response, you really do have to understand the amicus brief, and you really do have to understand how the Attorney General responded to it. Okay, so here we go. Appellant's reply to respondent's answer to brief of amicus curiae, if that's how you pronounce it. Okay, introduction. I'm going to zoom in a little bit here for my eyeball's sake. Okay. The First Amendment's ecclesiastical abstention doctrine provides, well, actually, let me say this. So this is coming from, okay, this is coming from Masterson. The First Amendment's ecclesiastical abstention doctrine provides that a civil court may not adjudicate the correctness of an interpretation of canonical text. Under the abstention doctrine, it is not within the judicial function for judges to act as arbiters of scriptural interpretation, nor are jurors in a criminal trial. It violates the First Amendment for jurors to determine the correct meaning of religious scripture. Here, in its amicus brief, the Church of Scientology contended that the trial judge violated both components of the abstention doctrine. First, the judge announced that she would personally interpret a portion of Scientology scripture herself. The judge then formally adopted an interpretation of this scripture that conformed to the prosecution's partisan reading of the passage. The judge rejected the authoritative construction of the scripture provided by the church itself. She then allowed the prosecution to present a partisan witness under the guise of a Scientology expert to tell the jury that the judge's version of scripture was correct. Now it's the judge's version of scripture. Okay. Second, the judge compounded this First Amendment violation by instructing jurors they could consider the prosecution's version of the passage as well as the remaining evidence about Scientology scripture offered at trial, not only for its relevance to the complaining witness's credibility, but for the truth of the matter as substantive evidence of guilt. This instruction improperly allowed jurors to evaluate the truth of religious doctrine and use that religious truth as substantive evidence of guilt. The state has filed an answer to a brief of amicus curiae. The state argues that the trial judge did not violate the abstention doctrine in interpreting Scientology scripture herself and refusing to defer to the church's understanding of its own scripture. In the state's view, the judge was not required or even permitted to defer to the church's own interpretation of its scripture. And there was no abstention doctrine violation in allowing jurors to consider the Scientology evidence for its truth, because in fact, the court permitted evidence about Scientology to explain the victim's conduct before and after the crimes. As discussed below, the state is wrong on both counts. The state's first argument ignores binding Supreme Court case law. Contrary to the state's position, the law is clear. Judges may not interpret scripture. When a church has provided an authoritative interpretation of its own scripture, that interpretation is controlling in secular legal proceedings. The trial court's decision to interpret scripture on its own, to reject the church's own interpretation and adopt the prosecution's version of scripture, and to permit the prosecution to present evidence that its partisan version was correct, violated the First Amendment. The state's second argument ignores the record. The record is clear that it was at the first trial that jurors were told the Scientology evidence was limited to assessing credibility and the conduct of the complaining witnesses. Oh, I guess they're saying as opposed to the prelim hearing. The record is equally clear that at the second trial, jurors were not given this instruction. Instead, they were told they could consider the Scientology evidence not just for credibility, but for the truth of the matter. Well, sure, but there was also an expert witness in the second trial and not in the first. The state steadfastly refuses to recognize this dramatic change in the evidence and instructions at the second trial. But these changes allowed jurors to do exactly what the abstention doctrine precludes, deciding the meaning of religious doctrine. And it allowed the prosecutors to weaponize Mr. Masterson's religion against him during a closing argument in which they painted Scientology as a nefarious organization which did not recognize sexual assault crimes like rape, precluded members from reporting other members to the police, punished members who reported crimes to police, and required its adherents to obey Scientology laws rather than laws of the United States. I don't know. That sounds like a good description of Scientology to me. Okay. Argument 1. The trial court violated the First Amendment's ecclesiastical abstention doctrine. Guys, I don't know if I can. I don't know if I can do all this again. It's the same stuff over and over and over. It's the same stuff, you guys. It's the same stuff. Let me go full screen for a second. Let me just go full screen. I'm just scrolling through this real quick. My God, they're just regurgitating. So you had the amicus brief, and then of course the state's response regurgitated so much of the amicus brief. So Danny's response is just regurgitating so much of the amicus brief and the state's response. Wow. Okay, I know how I'm going to do this. Okay, I'm going to do it this way. For all of our sakes. All right, I'm just going to take a sampling of it. Okay. Yeah, we're just going to take a sampling of each section here. Okay. Argument. The trial court violated the First Amendment's ecclesiastical abstention doctrine. The trial court improperly elected to herself interpret Scientology scripture and did so in a manner starkly contrary to the church's own interpretation. All right, so we'll just read a piece of this. At the preliminary hearing, the complaining witnesses sought to explain their delay in reporting the charged crimes by claiming that written Scientology scripture prevented them from reporting another Scientologist to the police. Specifically, on direct examination by the prosecution, Jane Doe 3 testified that Scientology doctrine, as reflected in the Scientology ethics book, prohibited reporting a Scientologist to law enforcement and treated such conduct as a high crime and a suppressive act. Okay, good. We've already heard this story. It's just retelling that story. Okay. Later, when Scientology provided an authoritative construction of the written scripture at issue, an explanation making unmistakably clear the court had gotten it wrong, the court refused to defer to the church's interpretation of its own scripture. Good. We've already heard this story. We understand exactly what they're saying here. Okay. We've heard all of this. Okay. All right, let's see what it says here. Finally, the state does not dispute that even after being presented with the church's interpretation of scripture, the judge permitted the state to introduce evidence confirming the incorrect interpretation the judge had earlier reached. It is no answer to suggest, as the state does in passing, that false testimony about church scripture goes only to the weight of that testimony. If the state was correct, and the vice of the false evidence about religious scripture went only to weight, then like any other matter in an adversarial system, it could be addressed by the presentation of competing evidence. But as the amicus brief makes clear, the First Amendment creates an exception for religious doctrine. That is, courts may not resolve religious disputes. Okay, I'm going to fast forward. It's becoming just really, really super obvious that there's just a fundamental disagreement about whether the court was taking a side in a religious dispute, when really it's not a religious dispute. And I really like the argument that even if the Scientologists' frame of mind was based on an incorrect interpretation of official Scientology policy, it wouldn't matter. It would not matter. I thought the state's response in that regard was great. Okay, so yeah, we're going to fast forward. Okay, B. The trial court violated the abstention doctrine by permitting jurors to consider evidence about Scientology scripture for the truth of the matter and thereby determine the meaning of religious doctrine. I mean, I guess I just feel the need to comment on this. It doesn't matter whether It is it doesn't matter whether the victim's interpretation of policy or Scientology policy, or even the expert witnesses' interpretation of policy is 100% in alignment with Scientology's claims of what is official church policy. It only matters whether they believed it was true. And it's not even a religious dispute. The case is about whether Danny Masterson raped women. The case isn't about who is right or wrong about Scientology policy. Okay. At the time of the charged offenses, both Mr. Masterson and the complaining witnesses were members of the Church of Scientology. At the first trial, the prosecution offered expert testimony about the religious practices of the church for the truth of the matter. The court properly excluded the evidence, ruling that Scientology policies were not relevant. What was relevant was what the complaining witnesses believed, which they could testify to themselves. In accord with this ruling, the court repeatedly admonished jurors that Scientology doctrine evidence was introduced solely to assist you in judging the credibility of the witness's testimony and to assist you in evaluating the witness's action or inaction taken regarding the charged incidents. The jury hung on all counts. At the second trial, the prosecution again sought to introduce expert testimony on church practices. Aware of the trial court's ruling and instructions at the first trial, the prosecution was careful to offer the evidence for a limited and narrowly tailored purpose, to allow the people to refute the implicit challenge to the victim's credibility. The trial court not only reversed its ruling as to admissibility of the expert testimony, but on its own motion went further and ruled that jurors could consider the Scientology evidence for the truth of the matter, to determine what Scientology doctrine is and whether defendant committed the alleged crimes. The court instructed jurors that the Scientology evidence it heard, aside from the testimony of Jane Doe 3's husband, could be considered for the truth of the matter. In closing argument, the prosecution team took full advantage of the trial court's dramatically different instructions at the second trial. The prosecutor argued that jurors could consider the Scientology evidence not just on the question of credibility, but for its truth, urging jurors that it showed what Scientology believes, that Scientology law, their rules, their principles, they guide everything. You must obey those rules over all other laws. The prosecution used this evidence to create an us society versus an other Scientology. Accepting the Scientology evidence for its truth, jurors would believe Scientology, 1, did not recognize rape, sexual assault, or things of that nature. 2, did not allow its members to report any other members to law enforcement. 3, punished members who reported crimes to the police, taking actions to discredit them and destroy them utterly. 4, required its members to follow the law of Scientology rather than laws of the United States. And 5, prevented members from taking medicine. The prosecution drove home these precise points, both in opening statements and in closing arguments. A central thesis of the amicus brief is that the trial court violated the First Amendment in allowing evidence about church doctrine for the truth of the matter. Again and again, the amicus brief makes clear that a central vice of the court's ruling was in admitting the evidence for the truth of the matter. Noting that the trial court admitted evidence of alleged Scientology practice and beliefs for the truth of the matter, the trial court violated the First Amendment in admitting evidence regarding Scientology doctrines and practices for the truth of the matter. Okay, blah, 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 blah. Amicus focus on the changed ruling, admitting Scientology evidence for the truth of the matter, echoed Mr. Masterson's own position. In his briefing on appeal, Mr. Masterson acknowledged that as the trial court ruled at the first trial, the complaining witness's understanding of Scientology doctrine was relevant and admissible with respect to assessing their credibility. He contended, however, that the starkly different ruling at the second trial, allowing jurors to consider the Scientology evidence for the truth of the matter and determine what Scientology doctrine actually is, violated the First Amendment. Appellant was clear. Although Scientology evidence was relevant and admissible as to credibility, in order to try and explain the complaining witnesses' delayed reporting for so many years, it was irrelevant and inadmissible for the truth of the matter to prove what Scientology doctrine actually was. In its answer, the state ignores the, oh wow, I've never seen this word. What? The ineluctable? Holy shit, what is that word? In its answer, the state ignores the ineluctable fact that the trial court's sua sponte? Okay. In its answer, the state ignores the ineluctable fact that the trial court's sua sponte jury instruction at the second trial was starkly different from its instruction at the first trial. At the second trial, the court instructed jurors that the Scientology evidence was not admitted just for credibility. I can't keep reading the same damn sentence over and over and over again. My God. Okay, we get the point. We get the point. There's a difference between admitting the evidence for the truth of the matter versus admitting the evidence for the credibility and state of mind of the victims. Okay, you guys get it. Oh my God. Okay. The state admits that even if the complaining witnesses misunderstood Scientology doctrine, their understanding at the time was still highly relevant to their credibility. It notes that right or wrong, what mattered was whether the complaining witnesses believed they could not report appellant's crimes to the police, but only to the church. But that is the whole point. As the trial court recognized at the first trial, whether the complaining witnesses were correct in their understanding of Scientology doctrine was beside the point. The state now agrees that the Scientology evidence was relevant to the complaining witnesses' understanding at the time and belief as to whether they could report Mr. Masterson. That relevance has nothing to do with the truth of the matter. Oh my God. My eyeball is literally about to explode out of my head from reading the same phrases and sentences over and over and over again. This is unbelievable. Oh my God. We're literally going to keep scrolling. Oh my God. Okay, the next section here. The hostility to Scientology shown by the trial court and prosecutor violated the First Amendment. I can't, you guys. I can't. I don't give a shit. He's just repeating the exact same shit. Okay, we're getting close to the end anyway. I mean, I think you guys get a sense that the substance of this appeal is bogus. So this ain't going anywhere. Oh my God. Scrolling. Oh, thank God. Conclusion. Okay. The First Amendment issues at the heart of this case are not complex. The First Amendment does not permit a court to determine the meaning of Scripture, disregard the church's authoritative explanation of its own Scripture, permit admission of a competing governmental account of that Scripture to the jury, and then permit the prosecution to rely on that account to obtain a criminal conviction. It does not permit jurors to decide the meaning of religious Scripture and use that understanding as substantive evidence of guilt. And it does not allow state actors to impugn a defendant's religion and church, full stop. Because that is what occurred here. And for the reasons set forth in appellant's opening and reply briefs, reversal is required. Dun, 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 dun. All right. That only took about 15 minutes. And we skipped over most of it. Oh, look at this. Bilfy says, full stop at the end of a paragraph is something AI often does. Yeah. Okay, guys. That was a lot. Let's just look at some starred comments and we'll wrap this up. What time is it? It's 8:30. Damn. I had another video I wanted to do tonight. I'll save it for tomorrow. Okay. Susie Q. Am I hearing this accurately? They're claiming that Danny raping these women as a religious experience? No. Matt Elliott, was this the one that had a bunch of invalid legal case references that the lawyer used AI to write it up? No. That was in the Bixler lawsuit against that was in the lawsuit against Scientology, Danny Masterson, David Miscavige, and everything else for harassment and intimidation. This is the criminal appeal here. Okay. Caroline, the gall to lie like this about following the law of the land. Hey, girl, Scientology thinks Word salad is law. Mrs. Bramlett Jr., they had a chance to put their own expert, who was Claire's stepfather, on the stand, but they chickened out. That's true. They were going to put their own expert on there, and they did. They did chicken out. And it was going to be Claire's stepdad. Andrea Malloy, I love that they call L. Ron Hubbard's Babel scripture. Yes, but it's not a faith. You guys, it's not a faith. Scientology is not a faith. They just call everything L. Ron Hubbard wrote scripture, but it's not a faith. It's not a faith. Matt Elliott, whichever lawyer wrote this up needs to be brought up on ethics charges for basically submitting false information. Northern Girl, abide by the laws of the land equals make a branch of Scientology that is dedicated to subvert all of the laws of the land. Adam Carmona, this brief is out tech and off policy, a total squirrel brief. Matt, wasn't Claire like third or fourth in line of RTC when she was at Gold? Oh, you got a contradiction here. Gold is not RTC. She was at Gold, and then she was at RTC. And it depends on how you define it. Like, I think when Claire is characterized as being third in command, it's not that there is literally, it doesn't like, it's basically how many people were between her and David Miscavige on the organizing chart. That doesn't necessarily make you, like, Marty Rathman is described as second in command because he only answered to David Miscavige. But there's a lot of people who only answered, not a lot. There's a number of people who only answered to David Miscavige. So I will also casually, use language that way, second in command or third in command, even though that's not really how the org chart works. Do you know what I mean? It's kind of like, even if you look at our government, Congress and the Senate and the White House, like, is it that you have, like, if the president dies, vice president takes over. If the vice president dies, does the Speaker of the House take over? So in that essence, could you call the Speaker of the House the third in command? Not really, right? But anyway, and that's an even more clear-cut example than in Scientology. But anyway, that's a long answer to your short question, Matt. Hazel says, who defines the laws of the land in Scientology? That's a problem. Girl, how does an upstat get in trouble or held accountable then? Basically, that's a good question. Ethics protection. So in Scientology, there's this whole hierarchy, not only within the organization, but of levels of organizations. And basically, whoever decides they don't give a shit about how productive you are, that's where your protection stops. Your protection is only as good as the person who's supposed to get you in trouble cares about your ethics protection. It's almost like when they say John Travolta was, made a cacon. Yeah, but who could unmake him a cacon? David Miscavige. Like that. Like, that's why none of these things in Scientology only matter insofar as people care about them. And so, yeah, you have ethics protection if the ethics officer thinks you have ethics protection. That's pretty much how it works. Okay. Rib Guy, the knowledge reports are filed with a yawn. Ethics officers are trained to then investigate who wrote the report. Yes. Kels, I think they just want to bore the judge to death with this mumbo jumbo. Adam, we're all in the course room. Caroline, every single sentence is either a lie or some kind of gross hypocrisy. What a feat. Anthony, so this proves that the LAPD was complicit too? Steve, is Tom Kakan? So when I was in Scientology, I never heard that he was officially labeled a Kakan, but Tom would be a Kakan. Adam Carmona, I wonder if Dave awarded himself Kakan. Exactly. But also if you're the guy at the top of the org board, there's no one to get in trouble with, right? So, okay, Matt says the name fair game would no longer be used, but nothing else changes, is what L. Ron Hubbard said. Exactly. Me and a coffee. This is real bullshit. I don't know whether to laugh or cry. Olga, how creepy and sleazy, trying to say that they are like all other tax-exempt religions, such polished liars. A girl, what a bunch of word salad to excuse rape as a religious action. Hazel, the way they use the word scripture is alarming. Linda, this is sickening. A girl, when a religion teaches the patrons not to report the crimes. No bigger red flag can fly. BSTA, this is Ken, right? I'm almost positive this is Ken. Okay, create your own religion. Church of Anti-Scientology. Yes. You know that Reckless Ben created a religious organization in California called the Church of Scientology Sucks. That's actually the name of the organization, and it has designated as a religious organization. Matt, since the defense didn't put up their own expert on Scientology, they only had what Claire told them. Adam Carmona, appellant is repellent. FBC, do you think Scientology will face justice for what they did to help cover up what Danny Masterson did? The jury is still out on that one. The grand jury, to be specific. 49ers fan for life. Does Danny have a good chance with this appeal? Hell no. Northern Girl, ineluctable means inevitable, inescapable, unavoidable. It describes something that cannot be avoided, changed, or resisted, even if you try to fight against it. Okay, there you go. Matt's Custom Creations. Whatever happened to the juror who threw the fix in the first trial? Is that the young woman that Chris Shelton interviewed? I don't know whatever happened with her. All right, guys, that's been 2 hours and 10 minutes. I'm dying over here. Thank you guys so much for hanging out with me. More to come tomorrow. Have a great night.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, oh, dancing for my love, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.